Good morning, and in my paper today, it's too long to read entirely, so I'll just briefly summarize a few parts and read a few others. As I started saying, I'm picking up the conversation in some sense where Pier Paolo Donati yesterday was referring to the possibility of a juridical recognition in some form of these relational realities within the family. And I'm looking specifically at the constitutions of the world. It is just a fact that the constitutions, that family law has been constitutionalized in recent decades. This is a universal phenomenon that has occurred for various reasons that I mentioned at the beginning. And I think that constitutionalization of family law, in other words, the treatment of the family in the Constitution as opposed to in what has traditionally been the private law of family law, is worth particular focus for several reasons. For the constitutions as expressions and instruments of constituting the basic values of society. In some sense, they represent what kind of a community or a society we aspire to be and to achieve. And therefore, they have this profound effect on our way of conceiving and acting on the reality of the family and its structures and relations. But perhaps most importantly, because it is at the constitutional level primarily that the family intersects with the language and conception and practice of fundamental rights. This what has become essentially the only lingua franca globally of ethics and justice and the common good. So for better and for worse, I believe the discourse of rights is shaping the family profoundly, and this is happening primarily through the constitutionalization of family law. It intersects in ways that allows the different conceptions of human rights, is a non-unitary idea, to shape the family and to, in some senses, reconstitute the family in the public imagination. Nevertheless, when I agreed at Pier Paolo's request to sort of go into this area, I actually thought the paper was going to be a lot easier to write. Because what surprised me as I found myself delving into this area for the first time, which is not my area, by the way, I was surprised to find so little scholarly attention has been paid to the question. There are single country studies of the constitutionalization of family law. There's almost nothing that is comparative in any substantial sense, and absolutely nothing that I can find that is comparative in anything close to a global scale. So what I've done here is go back to the origin. I went back to 197 constitutions of the world, pulled out all of the references and provisions to family in every single one of them, and then started playing with this data to try to figure out how to make sense of them. I identified 65 different distinct ways of engaging the family and sorted those into 4 then thematic subheadings, which I describe here. And I'm going to focus today really on sort of 2 fundamental questions within all of that. One is, how do the constitutions characterize and structure the relationship between the family and the state? And secondly, how does the conceptualization of rights, both the rights of persons within the family unit and rights of families as groups in society, get represented in these constitutions? Methodologically, I think I could say that the approach that I take is inspired by the cultural anthropologist Clifford Geertz, who famously referred to law as a distinctive way of imagining the real. So my question really is a hermeneutic one, not a technical, legal, or juridical one, but asking, how does the law in these constitutions imagine what the family is and how the family is lived? A few very global observations. Typically, you find about an average of 7 references to the family within global constitutions, but that varies from 0 to 30. There's wide variation. And the only one provision that is common to all, not to all constitutions, but to a majority of constitutions, 126 of them, is simply a generic statement stating that the family is to receive the protection of the state. And otherwise, there's quite a bit of variation. Notwithstanding the variation, beyond those general observations, you can begin to see, as you sort this data, a certain range of common poles of coherence, I think of them, in the underlying conceptions, especially as we begin to get to the relationship between family and state. Now, the poles that I'm going to mention are, of course, only heuristic and analytical categories. They're not absolute ones, and they overlap substantially in the reality of any one constitution. But starting with those constitutions, there's a set of constitutions in which the state is explicitly dominant over family life. That's not surprising that we find these primarily in authoritarian states. Among those, it's typical that there's no right to have a family, no privacy of the family, no requirement or protection of the family or autonomy of the family. The state may demand certain things of the family, such as, in particular, the use of family planning, and omit protection of the family in criminal proceedings, and most particularly assert their power to legislate regarding the family without any other constitutional limitations. The most obvious example of this and paradigmatic is the Constitution of China from 1982. Somewhat different from that first group of constitutions, but exhibiting less direct social control, is a group of constitutions that seems to have an ideal type of the family that is proposed. What kind of a family should be encouraged, and typically a quite high standard. They make various demands on the family, punish family members who fail to live up to that standard, suggest that families ought to be places aspirationally where certain kinds of important rights and responsibilities are found. Paraguay represents a good example of this model. A third one is essentially one that I characterize as envisioning the family as being the protectorate of the state, and especially a protectorate of the state in an economic sense. Families are supported actively and robustly, especially in their economic dimensions, and that happens through things like the protections for family lands, for family businesses, a guarantee of family wages or allowances, sometimes specifying certain other forms of subsidy of the family. And here, the 1917 Constitution of Mexico is not only a paradigm, but was really in its era a leader in envisioning a new form of constitutional relationship at a social level. The fourth category, and next to last, I'm running through these first ones quickly because they're of less interest to us, I think, given our theme. But the fourth category sees the family as, in some senses, constituting the state or building it up. And this approaches, the questions that we're asking in a certain way, importantly. Some go so far as to say that the family is more important than the state because it is there that the state or the nation actually begins, and that therefore the implications are often that the family is given a special kind of capacity to participate in the formation of public policies going forward. An interesting example. But the final one that I identify is the one I want to dwell on the most because it seems most consonant with the questions we're asking about the relational character of the family. There's a handful of constitutions that, beyond just seeing the family as important or as a building block of society, seem to express a view that the state is a subsidiary community whose purpose is to support and protect the more primary communities, in particular the family, in which the person flourishes. So this classically subsidiarity-oriented vision might not be as explicit as the other four in some constitutions, but it definitely comes out by way of implication in a number of them. An illuminating example I'll describe a little more fully is the Chilean Constitution of, it's typically called the Chilean Constitution of 1980. It was very substantially revised in 2005, and that's a controversial question that I won't go into. But in its very first article, it states, family is the fundamental core of society. Okay, so far, it's relatively similar to many others. But then it immediately goes on to say, the state recognizes and protects the intermediate groups through which society organizes and structures itself and guarantees them the necessary autonomy to fulfill their own specific purposes. And finally, it concludes immediately after that, the state is at the service of the human person, and its goal is to promote the common good, for which it must contribute to create the social conditions which may allow each and every one of the members of the national community to achieve their greatest possible spiritual and material fulfillment, with full respect for the rights and guarantees established by the Constitution. So what we have here is a clear and logical linkage of integral personal fulfillment with intermediate societies, and specifically the society of the family, as defining the basic institutional ends of the state. So it suggests implicitly but clearly that the family is both ontologically prior to and morally primary with respect to the state. It may not invoke the principle of subsidiarity directly, but this constitutional model can be considered to be an instantiation of that principle. Kenya and other constitutions are also exemplify this in other ways that I detail in the paper. So in sum, it's reasonable to say that these varying, as I said, partially overlapping models of family-state relation help to reveal not simply that families are commonly regarded as goods from a constitutional perspective, but more importantly, it shows important variations in what kind of a good they are relative to the state. Turning now to the second axis of analysis of the constitutional text, the recognition of the rights of the family as such and of individuals within the family, the distinctions to be made are a little more clear and essentially tend to be weighted toward one or the other of two paradigms. On the one hand, the family is understood as a mostly temporary conglomeration of individual interests, leading to a bundled collection of individual rights. On the other hand, the family is a locus of fundamental relationships between persons that are constitutive of human flourishing, and that therefore entail reciprocal rights and responsibilities among the members of the family, and that also serve as the basis for recognizing the rights of the family in public life more broadly. Most constitutions represent family primarily as a structure of individuals in instrumental relationships with one another, each of whom has individual rights either to the family or in the context of the family. The most common, for example, are the personal right to marry, the individual right to have a family, including the rights of children or the elderly to a family. Others found across constitutional systems include the right to safety within the family, the equal rights of spouses within the family, the right of access to family planning. Now, in a certain sense, one could characterize all of these. Indeed, one can characterize any human right in relational terms. Let's be clear, right? Because a human right is by definition a relationship of justice to someone else, right? But it's also important to see that all of these rights recognize and protect an individualized interest. It's not the relationship or the relational interest that is the primary object of protection directly, but the choices of the individual to enter into or to exit or to live freely and safely within this family. Or it entails the intersecting rights of individual members of the family, such as a child's right to protection or the equal right to spouses. So each is an interest that pertains ultimately primarily to an individual person. In this sense, they're consistent with the implicit but dominant theoretical justification of human rights in the contemporary world. They're understood to be individualized human interests of sufficient strength and importance to be given a special moral and legal recognition and status. One can't ignore the very strong influence that international human rights law has on this characterization. It is the set of rights related to the family that go beyond those individualized interests and that instrumental relationality that I think are most interesting for us to identify and reflect upon. The question of fundamental rights within and of the family begins to take on an interestingly different cast in that handful of states that also recognize specifically the duties that individuals have in virtue of the existence of the family. In most examples, the recognition of family duties suggests that they arise from a recognition that families are fundamentally characterized by the intimate and constitutive relations among persons. And as such, there are duties owed to each other in the relationship, as well as reciprocally correlative rights. Essentially, both the rights and the duties protect the interests of the relationship itself, of the relational unity that exists in the context of the family. I give several examples in the following paragraphs. I won't detail them here because I don't really have time, and it's important to get to the next section. Those observations are based really just on the constitutional text. Obviously, in any constitutional system, the text is only the beginning, the first chapter of the story. The constitutional practice, how those are interpreted, how those are applied to specific cases, is a necessary part of a proper understanding of what they really mean and what they imply in practice. So I try in the next section to look at, not comprehensively, I can't go through every court in the world, but to look at a few examples, in particular examples that relate to the last point that I was making about the relational understanding of rights. To see, essentially, to ask, in constitutional practice, can this be realized? What would it look like beyond a mere statement in an abstract text? And you can see from the examples that I give, I use three examples from three very different constitutions, very different parts of the world, very different cultural contexts, to confirm that, in fact, it is possible. There's several examples of the Italian court. I'll mention here in the margins that I don't mention in the text that it is not surprising that two of these examples were drafted by our new colleague at the Academy, former president of the Constitutional Court, Marta Cartabia, and that Marta and I, as well as some other colleagues, have argued extensively for a number of years about the importance of recognizing the relational approach that the Italian Constitutional Court takes. But another example comes from the Philippines, where its assessment of the reproductive health law and the finding of the unconstitutionality of that law with respect to abortion is very clearly grounded in a relational understanding of the family that needs to be recognized and protected. And the last example I give comes from Chile, where the Constitutional Tribunal last year ruled on the constitutionality of a law that deeply limited the autonomy of parents to help direct the education of their children, and does so again with language that is strikingly relational in its orientation. So why does all this matter? Why do the numbers in the constitutions matter? Why do the examples matter? I think it's because that in the reciprocity of rights and duties and the recognition of rights that arise out of the interests and nature of the relationship itself, we can see an importantly different way of conceiving of fundamental rights or human rights themselves, of the source of those rights and the nature of those rights. The standard conceptualization of contemporary juridical language regarding human rights, as I said before, is of rights as a means of recognizing and protecting in positive law certain important individualized interests. This is so much the case that some legal theorists have concluded that the concept of a human right as it is employed by international courts today is, strictly speaking, not what technically would satisfy the traditional juridical requirements for a legal right at all, because they don't have duties associated with it. They only contain two of the three necessary terms, right? They're open-ended and unlimited claims that an individual has to the object of any strong interest. So I and others have identified this problem as relating directly to the widespread problem of rights inflation and of the incapacity to differentiate between those claims of rights that authentically serve to safeguard essential and universal aspects of human dignity and those claims of rights that do not. I give a concrete example of how that might be the case, in particular drawing on parents' right to educate their children, and how that is might represent a different way of conceiving of rights altogether. And one important implication of all that is that the conceptual foundations of rights and responsibilities of and within the family unit might serve more broadly as a corrective to the contemporary tendency to view the rights bearer as purely an existentially lonely, autonomous monad, rather than as a dependent being. A dependent being constituted in and by relationships and by belonging, most especially relationships of love. It is not too much to dream, perhaps, that if we were to take the rights of and in the family seriously as relational rights, it might bring about a more integral and sound idea of human rights as a whole, in line with the powerful exhortation that Pope Francis gives us in Fratelli Tutti. And this is a quote that I can't help but read in its entirety, notwithstanding the limited time. He says, quoting from a prior very pointed speech that he gave to the European Parliament, he says, "The human person with his or her inalienable rights is by nature open to relationship. Implanted deep within us is the call to transcend ourselves through an encounter with others. For this reason, care must be taken not to fall into certain errors which can arise from a misunderstanding of the concept of human rights and from its misuse. Today, there is a tendency to claim ever broader individual, I am tempted to say individualistic, right? Underlying this is a conception of the human person as detached from all social and anthropological contexts, as if the person were a monad, increasingly unconcerned with others." And then the conclusion, "Unless the rights of each individual are harmoniously ordered to the greater good, those rights will end up being considered limitless and consequently will become a source of conflicts and of violence." Now, let me conclude simply by saying, obviously, we cannot be too naive about the immediate prospects for the realization of the Pope's vision. I've tried to emphasize that the possibility does exist, but we must also recognize it is a very small glimmer in the current constellation, perhaps, of law and constitutional law and international law. The relational view of rights is barely a crack in what can otherwise seem like a quite thick ideological wall of the conventional view that human rights merely pertains to individual interests. For every one judgment of a court that might be construed as refreshingly open to a relational understanding of rights, there are hundreds that are content to swim in the channel of this more orthodox expression of individualism and autonomy. Raffaella referred to some of them earlier that go to quite great lengths in asserting, for example, the human right to choose to have a child. It's paradigmatic of this. Frankly, the direction being taken in new constitutions themselves, not simply by courts, at least in some parts of the world, is not encouraging. In this paper, Chile's current constitution and court served as one of the clearest examples, both of a subsidiarity-oriented model of family-state relations and also of a relational approach in adjudication of the rights of the family. But that country is currently undergoing a complete and very radical rewriting of its constitution. The new proposed text, which will be submitted for approval in general referendum later this year, would eliminate essentially all of the current constitution's references to and protections of the family. But even so, just as the family itself is a starting point, the starting point, as we've heard here in the 2 days leading up to today, the starting point for all forms of development of the person in time, all authentic forms that correspond to dignity. Perhaps then even only a few cases and examples of constitutions and constitutional decisions that represent the family as a relational good in the juridical space could be, over time, the starting point for social development. Like mustard seeds placed exactly in those cracks, they will grow roots and grow to generate a genuine transformation in our thinking. Thank you.